Hi there, this is Jonathan Ginsberg. I'm a bankruptcy attorney as well as a student loan workout attorney, and I want to do this video to talk about how bankruptcy can be a tool to discharge or deal with student loans in some circumstances. And I did a previous video where I looked at section 523A8, and that is the Bankruptcy Code Section that really talks about how bankruptcy will treat student loans. And basically and 523 basically is the exception from discharge, meaning that exceptions to discharge rather, meaning that debts that fall in these categories cannot or may not be included in a bankruptcy and discharged as part of a bankruptcy. For example, debt incurred using false pretenses, or certain tax debts, non-dischargeable, certain domestic support obligations, non-dischargeable, fraud obligations, non-dischargeable, willful and malicious injury, non-dischargeable. And there's a whole bunch of different categories. There's one for personal injury caused by a DUI, non-dischargeable. But the one that we want to focus on today is Section A8, which basically looks at the student loans that are non-dischargeable. In the previous video I talked about one category of student loans, which is government student loans. And basically the way I read the code section, the way it's been interpreted, is you cannot discharge a government student loan unless you can show what is called undue hardship. And undue hardship has been defined by the courts under a test called the Bruner test, which is basically set out in this case called Bruner versus New York State Higher Education Services. And essentially it says if you can maintain a minimal standard of living, and that standard of living is going to be consistent throughout the repayment term, it's not going to change, you cannot discharge student loan debt. In the last video I talked about how we're seeing some cracks in that facade, such that some judges are being a little more liberal when it comes to finding undue hardship or finding debts partially dischargeable. And realize also with federal loans you have the income-based repayment program set up by the Department of Education. So even if your loans are not dischargeable, you can still get some relief by using an income-based repayment program and therefore survive on more than a minimal standard of living. Your student loan payments can never be more than a certain percentage of your income, and it's survivable. So I think that the problem we have in this country with all this student loan debt is you have all these people that signed off on student loans when they were 17 or 18 years old, and with no thought of how they're going to pay it back. And the schools have been jacking up prices because they have free money, and so you have all these people coming out of school with $100,000 to $150,000 in student loan debt, and their teachers making 35 or 40 grand a year, and the math just doesn't work. So I think the bankruptcy courts have seen some effort to try to resolve that problem or deal with that problem in some ways, and one way certainly has been to liberalize the definition of undue hardship. Now the second issue we got to deal with student loans is the private student loan market, and realize that in the student loan world about 75% of student loans are Department of Education loans, about 25% are private. And the big difference, at least in terms of resolving them, is there is no income-based repayment program in private student loans. So whereas with government loans, you can go to the Department of Education and fill out the paperwork and try to get an income-based repayment program and go on your merry way. But with with private student loans, non-federal student loans, there is no such thing. And so you have a situation where private student loan lenders have taken the position that 523A8 disallows discharge of student loans without undue hardship, and they'd have no obligation to do anything other than collect on them. And so you have a lot of people who are really suffering because they're being sued by private student loan lenders, and you really have no recourse. And if they sue you and get a judgment, they grab 25% of your pay. It can be really hard to survive. You can't buy a house, you can't have any sort of assets, any bank accounts, because all that money is going to be seized in a lawsuit. And so in some ways, private student loan debt is more protected than government student loan debt, which really doesn't make any sense at all. And I think courts are starting to see that. And so basically what we're seeing now, and this is an argument that's relatively new, but it's one that a number of attorneys I know are pursuing, and I'm looking at this, and I've co-counseled with several of them with some cases, and that is to say, well, private student loans may actually not be as non-dischargeable as we think. And you have to kind of really look at the statute. I'm not going to go into any great detailed statutory analysis, but I'm just going to show you a couple of things that have been successfully argued in court, bankruptcy court, and has given student loan lawyers an angle to try to argue that some of this debt is non-dischargeable. And in many cases, it results in a settlement at very favorable terms for our clients, for the debtor. So let's take, for example, let's look at the code section here, and you'll see that code section A1, little 1, this is talking about government loans. It talks about an educational benefit overpayment or loan made, insured, guaranteed by the government. All right. Go down here, however, and this number 2 here, this is not talking about any governmental unit. This is talking about private student loans. This says an obligation to repay funds received as an educational benefit, scholarship, or stipend. Okay, what you do not see here is the word loan. So you can make a very reasonable argument that this is not the same thing. This is talking about two different things, and in fact courts have basically accepted that argument and essentially said, and the argument's basically been made, that if the loans issued, the money issued, the educational benefit issued, was more than the cost of education, it becomes something other than educational benefit, scholarship, or stipend, and therefore can be dischargeable. So for example, if the cost of education was $20,000 a year and you received a payment from a private loan company of $25,000, which covered maybe, and let's not even include room and board, but let's cover just additional money to survive, to live on, then that may not be a non-dischargeable debt. And several courts have accepted that argument. And even if the courts don't accept the argument, the student loan lenders, private student loan lenders, have been willing to settle, because what they have done when they securitize these loans, which means that they are selling them to the market, just like real estate loans and car loans are securitized on Wall Street, one of the things they reveal in their securitization documents is these loans may not be non-dischargeable student loans. So they're aware of it. And so they don't want a lot of bad precedent. They don't want courts coming down with decisions that in fact these loans are not student loans that are non-dischargeable. That's one argument that's been made. A second one here, and this is something that is kind of a little more common sense, is this limits non-dischargeability to an educational loan that is a qualified education loan, as defined by this code section of the Internal Revenue Code. Well, let's go to the Internal Revenue Code. What is an eligible educational institution? It gives you a list, and you go here and it gives you a link to a spreadsheet, and the spreadsheet is here, and basically this is a list of all the schools in the country that are qualified. And if you went to a school that is not on this list, that's not qualified, then guess what? You have a dischargeable loan. And there have been some cases. There was a big case here. This is one out of California where a debtor had a private loan that was used for, I think it was a bar study course, but this was not a qualified educational institution. And the judge in this case said this loan is a 2017 case, and again it's a bankruptcy court case, not a district court case or something with a lot of precedent outside of California. But bottom line is the court said this is not a qualified education loan. And there are other types of schools that are not qualified by the IRS, so those loans are de facto dischargeable. So just because you have a loan that somebody's calling a student loan for something you got an education for doesn't mean it's a qualified education loan. And if the amount of the loan was in excess of the cost of going to school, and it was for something else, it was maybe just an additional personal loan, or it's way above the cost of education. Typically, it's got to be more than $500 over the cost of education. But let's say it's $5,000 or $10,000 over the cost of education, then you have a pretty good argument that these loans are non-dischargeable. And in the bankruptcy world, that means that, and what's interesting about this is that unlike with the government loans where you have to actually go litigate this, if these loans are in fact, these private loans are non-dischargeable, they are non-dischargeable as a matter of law. So as soon as your bankruptcy discharge is issued, you have discharged those loans. And if those lenders come after you, collect against you, then they are in violation of the bankruptcy discharge stay, and they're also in violation probably of the Fair Debt Collection Practices Act, and also the FCRA, the Fair, the Credit Reporting Act, the Fair Credit Reporting Act, and you could theoretically collect damages against them, or you at least use that as leverage to reduce the amount of the indebtedness and settle for a very small amount of money. So not every loan, not every private loan is non-dischargeable. Not every government loan is going to be, you're going to be able to show undue hardship. But the point is, as you can see, there are now some arguments that we can make, either to get the loans reduced or possibly even discharged, and the leverage could be, certainly in the private student loan area, the leverage would be that these lenders, for years after your bankruptcy, have been violating your rights and violating the law. And again, it gives you some real leverage to pursue relief. So again, there's a lot more to this than what I'm giving you here, but I just want you to see that the general perception out there that student loans are non-dischargeable and not exactly quite so true anymore. And if you have a situation where you have a private loan that may not be a qualified loan, or the amount of the loan was way in excess of what the school, your room and board, your school cost was, you may have an argument that this loan is in fact dischargeable. And I'd be happy to chat with you about that if you're in that situation, or if you filed bankruptcy in the past and you had student loans that maybe fit these qualifications and were in fact discharged, and maybe you have an argument to go back and reopen the bankruptcy and to litigate the discharge stay violations and the Fair Credit Reporting Act violation of the lender. So I realize this is a lot of complicated stuff, but I hope you found it useful. If you did find this valuable, please give it a thumbs up on YouTube, like it on Facebook, subscribe to my YouTube channel, and like our Facebook page. And if I can be of assistance to you in kind of walking through these student loan issues, I'd be more than happy to do so. My name again is Jonathan Ginsberg. You can reach me at Ginsberg, my last name Ginsberg @gmail.com, and I hope to hear from you soon. Thanks a lot.
Hi, this is Jonathan, and I hope you found this video helpful. I'd like to invite you to download my free Debt Destroyer Survival Kit right now. I've packed my survival kit with answers to the questions I've heard from clients for over 25 years here in the Atlanta area. Inside the survival kit, you'll find clear, easy to understand answers to critical topics about how to solve debt problems once and for all, including how do I protect my stuff, my house, car, and personal property if I file for bankruptcy? Are there any legitimate alternatives to bankruptcy? Will I ever get credit again, and if so, when? What mistakes must I avoid to get the most benefit out of bankruptcy? You can claim your copy right now by visiting my atlanta-bankruptcy.com website. And you are always welcome to use the email form on my website to ask me anything about debt and personal bankruptcy in Atlanta. www.atlanta-bankruptcy.com. And as always, I wish you the best.